while the CAC referred with approval to other jurisdictions where the effect must be direct and substantial. So as already noted, what CAC 2 was actually about was about whether the Commission's referral affidavit of June 2020 complied with the prescripts of the detailed order in CAC 1 and other applicable procedural rules. In other words, the issue in CAC 2 was whether the June 2020 referral affidavit made out a case for personal jurisdiction in respect to the foreign peregrini with reference to an adequate connecting factors test, and subject matter jurisdiction in respect of all foreign peregrini with reference to a qualified effects test requiring an immediate and substantial effect which was foreseeable, as well as whether the Commission had adequately pleaded a case regarding a single overarching conspiracy, SOC, against all of the bank respondents. Now, the Commission contends the CAC erred when conducting that inquiry, which was largely an auditing exercise with reference to paragraphs of the order in CAC 1, because it failed supposedly to have regard to what was required under Tribunal Rule 15.2. But the Commission was wrong in that regard. The various pleading prescripts in the CAC 1 order reflected the CAC's judgment as to what Rule 15.2 required the Commission to plead for a case of an SOC against the various foreign and local bank respondents. And if the Commission did not agree with the CAC's findings and the resultant precepts, it should have taken the relevant paragraphs of the CAC 1 order on appeal, but it did not do so, instead being content to comply therewith. Now, the CAC's conclusions regarding the adequacy or otherwise of the Commission's pleaded case in the June 2020 complaint referral are party-specific. It held the Commission's allegations in respect of some bank respondents sufficed, but didn't suffice in respect of the majority. And I'll therefore address that issue with reference to the case made out against the 3 Bank of America respondents, all of whom must be assessed individually in respect to the allegations against them. But before performing that exercise, it's important to make 3 preliminary observations. First, the BOA respondents comprise 1 respondent, Bamley the first respondent, and 2 parties referred to as purported respondents, as they are not yet respondents, but rather parties whom the Commission desires to join as further respondents, MLPFS, the 20th respondent, and Banner, the 21st respondent. Second, the inquiry in relation to those 2 categories of respondents is different. As Bamley is already a party, the question is whether Bamley can succeed in getting out of the case by means of an exception. By contrast, because MLPFS and Banner are not yet parties, the question is whether the Commission can show that they should be brought into the case by virtue of being joined as additional respondents. And third, and relatedly, the test in respect of those categories of respondents is also different. Firstly, the test in relation to Bamley is the usual test in exceptions, and thus involves a consideration of whether the facts alleged by the Commission in its replacement referral suffice to show both the Commission has jurisdiction over Bamley, a foreign peregrinus, a pure foreign peregrinus, and that Bamley is prima facie implicated in the SOC alleged by the Commission. As the CAC observed in CAC 1, there's some overlap between those aspects, because if the Commission pleaded a non-acceptable case about Bamley's involvement in an SOC involving South African banks designed to affect the ZAR, then there would likely be sufficient connecting factors to justify personal jurisdiction against Bamley, foreign peregrinus, and there would also be likely to be sufficient allegations to satisfy a qualified effects test and thus make out a subject matter jurisdiction. The test with regard to MLPFS and Banner, on the other hand, is the usual test applicable to joinder applications. One is thus not confined merely to what the Commission has alleged, but can instead look at what the potential or purported respondents have put up in answer, and what, if anything, the Commission has stated in reply thereto. Further facts can therefore be considered in that context, and regard can also be had to factual issues that are common cause. The Commission has confused the different inquiries and tests with regard to the B3 BOA respondents and also misrepresented the position applicable to them and what has been asserted on their behalf in particular. Now, the Commission contends that Bamley, MLPFS and Banner brought what were effectively dismissal applications, but they did not. Bamley instead brought an exception, albeit using the form the Tribunal appeared to sanction for exceptions, presumably in light of Tribunal Rule 42, and that cast just arguments and affidavits. The directives of the Tribunal show that they regarded exception applications as the way to proceed. And MLPFS and Banner opposed joinder applications brought by the Commission in which they exchanged affidavits with the Commission in response to the Commission's founding affidavit. Now, the Commission furthermore alleges that the BOE respondents impermissibly sought to add facts in an exception. but that misrepresents the case presented on exception. Bamley's exception was argued with reference to facts put up by the Commission, but what Bamley did also assert was that the Commission and the Tribunal and the CAC could not sensibly ignore facts which were not disputed in the joinder application and were in fact used against other BOA entities in that context when adjudicating the exception application of Bamley. Now, the Commission contends too that the reliance on common cause facts in the joinder application was somewhat impermissible, and indeed a stratagem to introduce selective new facts through the back door pre-pleading. But there's obviously no merit in that contention. It was clearly competent for MLPPS and Banner to rely on the full conspectus of facts in their joinder applications to resist their joinder. Now, before proceeding to consider the cases the Commission has made out against the 30BA respondents, which I have 10 minutes, it's also appropriate to note there appears to be agreement between the Commission and the bank respondents regarding the requirements for the existence of an SOC, which in line with European jurisprudence such as team relocations, as well as a US case law, and was held by the Tribunal in CT1 to involve three requirements. First, the party alleging the SOC had to show, one, the existence of an overall plan pursuing a common objective or identical purpose, two, the intentional contribution by that firm to that plan, and three, and this is important, the awareness, proved or presumed, of the offending conduct of the other participants. Now, it's convenient first to deal with Banner, the 21st respondent. The Tribunal joined Banner in CT2 essentially on the basis that Section 59(3)A of the Competition Act purportedly allowed a holding company to be liable for the actions of a subsidiary, but the Commission obviously does not, understandably does not seek to defend that wrong finding, which was overturned by the CAC and CAT2. But the Commission argues that unlike the other holding companies against which it no longer proceeds in the light of its abandoned reliance on Section 59(3)A, Banner should still be joined because it may have employed one of the two traders, Cook or Shepherd, who is said to have acted on behalf of a BOA entity. Now, the Commission groups Banner together with respondents such as JP Morgan and SBSA in its heads of argument and argues in this regard that Banner, like those respondents, could not seek to introduce new facts to get out of the referral before pleading over. But that is an obviously bad argument because the other two entities referred to are respondents seeking to escape the referral by way of exception. By contrast, Banner, as mentioned, was a purported respondent whom the Commission is seeking to join as a further respondent. So unlike in the case of the other respondents to the original referral, regard can obviously be had to the affidavits and evidence in the joinder application. Now, the Commission alleged in its founding affidavit in support of the joinder of MLPS and Banner that Banner could have employed Cook. It didn't mention Shepherd until June 2020, and the Commission's mention of him can anyway be disregarded, as I shall explain briefly below. Now, the first answering affidavit of MLPS and Banner in opposition to the joinder stated unequivocally and clearly that Cook was employed at all material times by MLPFS and only represented MLPFS. It was also observed the Commission never bothered to contact any BOA entity or the BOA respondents' attorneys to seek to establish which company could potentially be implicated by Cook's actions. The Commission, in reply, referred to and attached the BOA respondents' attorneys under oath. Now, the relevant parts of the affidavit, it's 1190 and following is the Commission's reply, and 1277 and following is the BOA respondents' answering affidavit in the joinder. So the Commission acknowledged that, attached the affidavit of Sean van der Meulen, but did not provide any controverting facts or any serious basis for challenging those sworn statements. It's thus effectively undisputed in the joinder application that Cook was not employed by Banner, but instead by MLPFS. It's also clear the Commission has no facts evidencing or even suggesting the contrary. Now, the high watermark of the Commission's case is that Cook signed into the old GITS chat room at various times with an email address ending at baml.com or at ml.com. The Commission states that it therefore infers, that's its words, that Cook was employed by BAMLI and or MLPFS and or Banner, and that thus one of 7 possible employment options existed. But that inference is not a remotely reasonable one, let alone consistent with all the pleaded facts. It was instead uninformed conjecture. Neither of these email addresses suggested Cook was employed by Banner, a North Carolina company, nor contrary to what the tribunal erroneously stated in CT2, is Banner the holding company of MLPFS. It's instead a company in a different branch of the Bank of America group entirely. Not only is there no reason to infer that Cook was employed by Banner, there's also no basis to suspect that the BAA group would later seek to suggest that its attorney statements under oath about Cook's employer were incorrect. Now, the Commission suggests today that in fact they're relying on authorization, but that has never been raised before, it's never been pleaded, and with respect, it's contrary. It is also not supported by an inference. Basically, what the Commission was saying in their referral, they were trying to catch the person under any company, saying you employed, you authorized, you represented. It is quite clear that he was employed and represented MLPFS, and that has not been contradicted. Now, the positions of BAMLI and MLPFS can be dealt with together, albeit that one's a respondent, one's a purported respondent, both are pure peregrini. Now, as a bank can only be implicated in SOC through a trader, the starting point of the inquiry must be an examination of the allegations made in respect of the traders whom it's alleged traded on behalf of BAMLI and MLPFS, namely Cook and Shepherd, and that inquiry must also be conducted with reference to the facts that the CAC said must be pleaded in CAC 1. For example, the fact that you're relying on inference, you must give the material facts on which you rely, and you must also plead adequate connecting factors, etc. Now, almost nothing is averred about Shepherd. He was mentioned for the first time in the June 2020 replacement affidavit and was then only referred to 3 times. All that is mentioned about him is that he's supposedly an employee of BAMLI and or MLPFS or Banner, which is an inference they say, and that he's a member of the Old Gits chat room. Now, these various mutually inconsistent allegations about his supposed employer are by the Commission's own admission an inference. There's no factual basis for the inference. There's, for example, no allegation of where Shepherd traded, what login email he used to enter the Old Gits chat room, if he ever did. It's not known if he had any contact with any other named traders, or if he did log into the Old Gits chat room, who was there at the time or what was discussed. The Commission has therefore not pleaded facts about Shepherd which could be relied upon to show that BAMLI and or MLPFS joined the SOC, or that there are adequate connecting factors between either of them and the jurisdiction tribunal, and it's not provided sufficient basis for the inferences to be drawn. And it should also be noted that the Old Gits chat room, it's alleged the Old Gits chat room did not serve any legitimate purpose. As the tribunal remarked in CT1, that omission is important, for if the chat room existed solely to further the conspiracy, one might understand an argument that you could not realistically join it for benign purposes. But if it could be used for both benign and malign purposes, simply joining it wouldn't result in an inference. Another consideration, as the Commission also noted in that context, is whether chat room is specific to rand-dollar trades, or if other currencies were also traded, as the initiation statement suggests at record 483 and 490, the notion that joining the chat room to further a ZAR USD conspiracy is further undermined. And in addition, it's been held in USA exchanging information about trading prices is not necessarily unlawful, to some extent necessary in forex trading. So we should respectfully submit nothing can be drawn from the allegations about Shepherd, and BAMLI and MLPFS cannot be brought into the case on that basis. Therefore, the case depends on Cook. Now, this must be considered with a reference to the fact it's essentially common cause in the joinder application that Cook was at all material times employed by MLPFS and represented MLPFS. We submit it would not be sensible or practical, according to the interests of justice, or consistent with the standards expected of the Commission as a public body, to proceed on that basis when joining MLPFS, and yet ignore that fact when considering the position of BAMLA for purpose of the exception. This is more particularly because the Commission has not alleged as a fact in its replacement referral affidavit that Cook was employed by BAMLI. Instead, it, as mentioned, alleges 7 mutually inconsistent alternatives involving his login name, BAML or ML.com, and they cannot reasonably lead to an inference that the position has been misrepresented under oath by the Bank of America's attorney. In any event, the allegations regarding Cook are inadequate to make out a case that he is involved in the SOC contended for by the Commission, and more particularly in SOC with South African banks, which had as its purpose the manipulation and distortion of normal competitive conditions in the trading of the USD-ZAR currency pair. Now, the Commission prepared various diagrams which are attached to the CT2 decision. The first diagram, Annex B, shows the chats or other communications between the respondent banks. The second shows trades between local banks or local banks and foreign banks. And the third one, if they try to combine the two, is an intermeshing of the both. But these diagrams and the allegations in the June 2020 replacement referral on which they were based do not make out a case that Cook, or thus Cook's employer, was part of an SOC involving South African banks. Cook is not alleged to be involved in any of the trades involving local banks mentioned by the Commission, so no BIA company is mentioned in the second diagram. Cook is not alleged to be involved in any chats with any South African bank, and there are therefore no lies between the BOA block in the second diagram and SA Bank. And thirdly, no South African bank's representative is alleged to be a member of the old GITS chat room of which Cook was a member. So Cook was a member of the old GITS chat room which just had foreigners, and he never spoke to any South African or was involved in a trade with any South African. The case then is based on involvement in the old GITS chat room, but as we point out, old GITS chat rooms not alleged to be set up for nefarious purposes or only for the ZAR USD trading. Cook was not a member of the ZAR chat room, which one can assume had a ZAR focus, and therefore we submit insufficient allegations to infer that Cook intended to join an SOC involving South African banks. Now, the Commission argues that the CAC implied the wrong test by looking at whether there were any links between Cook and an SA bank, rather than considering whether there was a link between Cook's employer and the SOC, which involved SA banks. But that does not accurately reflect the CAC's approach. The CAC held there was no reasonable basis for inferring a link between Cook's employer and any SA bank, or thus a link between Cook's employer and an SOC with a South African bank. And that is dispositive because it will be recalled that the third requirement for an SOC is that a participant must have been aware or could reasonably have been aware of the offending conduct of the other participants and thus the nature and scope of the SOC. It was therefore necessary for Cook's employer to have sufficient to know or have sufficient information to know. Can I finish the paragraph or the sentence? The sentence. Oh, it can't be a long sentence. Let me get my sentence. It's sufficient, so it's necessary for Cook's employer to know or have sufficient information that it could know of the actions, intentions of the various banks, and also have actual or deemed knowledge of the other foreign banks which are not in the old GITS chat room with which Cook did not interact, something which, of course, is... Thank you very much. Thank you.